Great. Thanks very much for talking with me again today. I want to ask you a little bit about Senate Bill 1008 and how it changed the way juveniles are prosecuted when charged with Measure 11 crimes. And as you know, instead of automatically waiving them into adult jurisdiction, they are evaluated on a case-by-case basis. I was wondering what would guide your philosophy in terms of whether to recommend that a juvenile be tried as an adult?
Well, no, that's a great question, both in light of the legislative changes and obviously the story that your paper just reported on a recent case. So by way of background, obviously I've got considerable experience handling Measure 11 cases over the years and handling adult cases where you have offenders who have been through the juvenile system. So I've seen the spectrum of behavior as a prosecutor over 2 decades, and really the spectrum of behavior as it relates to defendants. So to answer your question, what would guide kind of my standards, I guess, or my criteria that I would impose internally for referrals to adult court? I mean, the statute contemplates, and to the extent possible, I would truly have a case-by-case examination of when it's appropriate. I mean, you want to look at a number of factors like you do in any sentencing or sort of factual determination. You want to look at the offender's history, and by history I mean history of violent offense or offenses, or unwillingness or amenability to treatment or supervision. Those are big factors. And all of this, of course, is part of the larger context of evaluating juvenile offenders with the cognitive developmental issues we know they have relative to the adults. And I'm both familiar with the literature and the facts in those cases. So you look at that piece, and then obviously you need to look at the facts of the underlying offense. I mean, not all violent offenses are created equal. I mean, they all may meet the statutory criteria, for example, a robbery or a homicide. But factually, they're different. And again, the case that you folks have reported on the last few days, I think, underscore that fact, that there are circumstances in which an offense can be so egregious that maybe referral is not justified. And by the same token, there are offenses that meet the elements of the offense that we need to say, well, this is someone for whom incarceration only till the age of 25 is indeed appropriate. And I think when I say case by case, I want to add one more thing. I think the number, statistically, the number of cases that meet sort of that criteria or would fall under the umbrella when you have to look at them is small enough that you could indeed impose a case by case, sort of a policy or criteria to examine those within the Multnomah County District Attorney's Office. So I think it's a viable policy. I'll say that as well.
So talking about the Yamhill County case, where it involved, I believe, 17-year-old who stabbed, or rather slit the throat of his father's girlfriend, beat her with baseball bats, and then after she was dead, sexually assaulted her, according to police. What is your take on the judge's decision and his comments in the story that he really had no choice but to keep him in juvenile jurisdiction as opposed to treating him as an adult?
Well, I mean, that's the piece that I asked myself that same question, what's missing here, right? I mean, because it's like, and anytime, you're kind of looking outside in, I don't have all the facts. So my take on the judge's comment that he had no choice would seem to suggest a deficiency in the statute or the statutory criteria, but that isn't really spelled out, right? Because, we don't know what precisely he is looking at in making those findings and that determination. I mean, what I read factually, given the age of the offender and what occurred there, that seems to me a case that should have landed in adult court. And I say that just knowing what I read. I don't want to overstate my knowledge. But that would suggest there's something missing in the statute. I don't know what that is, or if there's a fact that I don't know that the court felt it was bound by.
Kind of with that in mind, and recognizing that there are extra protections against, or rather that juvenile court it operates in its own special sphere in terms of public disclosure, would you support having transcripts of the proceedings be made public, in the sense of how do we find out what exactly happened and whether the judge is appropriately applying the law, or if there's a deficiency in the law, without having that kind of public scrutiny?
I think on first blush, I mean, the answer is yes. With respect to the factual findings, I would be very careful about protecting information about juveniles in that context, right? I mean, if there is a concern or question about the judge's factual finding, and that's based on, publicly available facts in the case, I think those should be publicly available. I would want to be careful, again, about revealing information as it relates to any juvenile. Because if there's not a finding that the juvenile should be referred to adult court, I'd be concerned about releasing information about that youth publicly that wouldn't otherwise be released. But I think what you could do is either have a requirement or alter the statute in such a way that if the referral is not made, the judge needs to either have a written finding that can limit publicly sensitive information, or make those findings publicly on the record. So with that caveat, I would suggest that is indeed appropriate. And if we see more decisions like this, we may get there. I mean, that may be what the public demands and what we need to do to tweak the statute. I mean, the problem with, I don't know, say rushing, but with, changes to the system like this is we don't know how they're going to play out. And we need to be open-minded to modifications or changes, I think, when we impose, changes to the system itself.
So one question I have refers to your time as a federal prosecutor, and recognizing it's a completely different system, but you were the lead prosecutor on the Muhammad case, and when sentencing came up, the government recommended 40 years in prison. He was ultimately sentenced to 30 years. Certainly there's an argument to be made that Muhammad was 19 at the time, and certainly his defense would argue that he was entrapped into pushing the button on the fake bomb. But they note that he'd been isolated, and in many respects he'd been given money and advised not to tell anything to his parents. Meanwhile, these undercover FBI agents had really befriended him. Is this, especially kind of in light of, the recognition that juveniles, granted usually under 18, are viewed as still developing, that their brains are still developing, that the sense of culpability is different. Do you think that that was an appropriate handling of that case?
Well, yes, and let me give a little bit of context. I think, first of all, the recommendation of a 40-year sentence was actually less, and this was publicly disclosed, than many wanted and what the guidelines recommended. In other words, it was suggested that we should have recommended, both nationally and by the guidelines, should have recommended a life sentence. And, I had advocated, and my office ultimately advocated for less than that. So you have to start from that framework. And in serious sentences, the age that one is an adult in the criminal system is still 18. So, I think the starting point is we recommended a sentence that was less than the guidelines and less than many recommended or suggested we recommend. Now, secondly, let me talk about the facts in that case, because you raise a fair question. I mean, he was young, is young, and you have to keep that in mind. It was an atypical and extraordinary case. I mean, there was no defense of diminished capacity, notwithstanding the millions of dollars spent in his defense. The jury heard from an expert regarding his cognitive capacity, and they also heard years worth of tapes and writings produced by Mr. Muhammad, all of which underscored an adherence to a violent ideology that really was extraordinary. Extraordinary in the sense that our expert talked about the fact nobody else in the West had written so deeply and profoundly about advocating violence on behalf of Al-Qaeda. Mr. Muhammad himself was quite bright, and throughout the process evinced a willingness to kill and participate in the process up and until the day of the bombing, when he thought he saw his own mother minutes before pushing the button. So you're talking about someone who engaged in behavior that really was extraordinary. And I think that the job of any prosecutor is to take into account all of the facts or factors in a case, both at the trial phase and in the sentencing phase, and we certainly did that. And I'll lastly say, that notion of entrapment and the appropriateness of his sentence was taken into account by the trial judge, the jury, the Ninth Circuit Court of Appeals, and the U.S. Supreme Court, all of whom at various levels and points in time during the process both rejected the entrapment defense and, the Ninth Circuit Court of Appeals in a 3-0 decision with one of the most liberal justices, or judges, I should say, in the United States, rejected that argument, the entrapment argument based on his age in part and the conduct of the undercovers. And so I think, again, you raise an excellent point about, how do we address the actions of juveniles in the system? And I think our conduct in that case sort of gets me back to where I started, which is we need to look on a case-by-case basis. And that was certainly a case that was atypical, an approach on a case-by-case basis where the outcome we believe and the courts have agreed was appropriate.
Switching gears a little bit. I'm not sure if you saw the story recently about Multnomah County dismissing, or finding irregularities by its mental health court employees, where an investigation found that one of its employees apparently was working on her own business at the time that she was supposed to be meeting with clients. Others were not meeting with their clients as intended. And rather than face termination, and I don't know if it was all four resigned, but it was basically they chose resignation as opposed to termination. What can the Multnomah County DA's office do to ensure that, or should it have done anything to ensure that these various services being provided to people within the system are actually being administered?
Well, I think the example you give when we're talking about county employees in the mental health system, and I think sort of on the Venn diagram of, issues that overlap with the district attorney's office, both in their administration of services and, as I understand it, in a review of their conduct. And you allude to that with the termination piece. And I'll say at the outset, frankly, this is why you need me in this job, because of my, extended experience in the system in managing, frankly, difficult situations like this and internal investigations. So to answer the question, what could the district attorney's office do? There are two things. On the programmatic side, obviously, the district attorney's office, to the extent they have control over the servicers of the specific programs, they need to be working with the county to ensure that quality services are being provided on the probation end or in any way connected with the courts. But there's a larger issue here, and that is, we need someone with independence and credibility to investigate these sorts of things when they come up. I don't want to opine on whether or not those individuals engaged in criminal conduct or anything close to it. But I've got experience managing public corruption investigations. And you need to have someone, when we get into that space where there is conduct that may indeed be criminal or need an appropriate referral, someone leading an office who's independent and understands the nuance involved in those sorts of cases. So I think that really is more directly responsive to your question. What can the district attorney's office do? The elected district attorney has a responsibility to enforce the law, and that extends beyond simply the common, street crime, essentially, that people see it to be. It extends to, public corruption, the public trust, and ensuring that all employees are managing their responsibilities in accordance with the public faith.
And finally, one question I had was just about, is there a different way to manage some of the repeat drunk drivers that we're seeing come through the system over and over and over again? And it's not just drunk driving. It's, it's basically irresponsible or reckless behavior with in driving. Certainly the concerns of, that is a very clear public safety issue. And as the number of deaths in Portland alone so far this year, it doesn't seem to be abating. Do you have any thoughts in terms of what needs to be done differently?
I do. And, I've got extensive experience in the past handling vehicular homicide cases and managing the DUI intake unit a lifetime ago. And I think traffic within the police bureau is a unique issue. And so my thoughts really then relate to two separate areas. One is enforcement, and then the second is prosecution. So on the enforcement side, that's a police responsibility. But the district attorney's office needs to work closely with the police. And obviously, I have their support. And I think that'll matter when we talk about what changes or what we need to do to work on the traffic side. And they need officers to do that. I mean, the reality on the enforcement side, there are some things I'll talk about in a moment about what you can do differently for your repeat offenders. But it's an enforcement question. You need to have a certain number of patrol and officers out on the roads to catch folks who are weaving in and out of traffic, and not after they've already crashed into someone. We have a reactive model that works for vehicular homicides or acute traffic incidents, but that doesn't work as well in sort of the prophylactic piece, which is what DUI enforcement is about, right? You want to arrest someone before they hurt someone. So they need more resources on the enforcement side on traffic. On the prosecution side, over the years, we've used a couple different models. The DISP, DUI Intensive Supervision Program, was pioneering, and it works pretty well. The trick is, and I talked about this when we had our larger interview about sort of a lot of these alternative programs. You need the resources to supervise these people on probation, and they've been cut by the county commission repeatedly. So in other words, you can put someone in a DUI intensive supervision program, but they're likely going to reoffend unless you've got active supervision and ensuring that those UAs are clean and that the breathalyzer device attached to their car is properly managed. And the same goes with sort of the courtroom management of that program. Now, the DUI offenders are a little bit different, and they have a slightly different management issue, but that speaks again to a different kind of probation management issue. So I would extend the DISP program. And I guess lastly, you can do sort of discrete targeted enforcement and prosecution programs based on geography and the type of problem. So for example, there right now is a speed racing issue. If you're going over the Fremont Bridge, apparently now there's a chance there's gonna be a speed race going on. And so, the PBB can increase, saturation of patrols in that area, but then what you need to do is ensure that the DA's office doesn't let those fall through the cracks as if they were just some other traffic incident that came through. If you have 10 reckless driving cases that come through associated with an acute saturated patrol effort, you need to ensure those folks are prosecuted because it does have a deterrent value. And I've seen that historically. So you can do that. And then on the geographic side, which you can do, for example, we've had a lot of traffic issues on Marine Drive in the past 2 to 3 years. You can isolate patrols in that area and do DUIs. You can't do checkpoints. Those aren't legal in Oregon, but you can do more patrol in coordination with the DA's office. So again, there are sort of, I'll say surgical efforts you can do on the enforcement and prosecution side, and then programmatic, and those speak to, I think, resources on the probation side.
Great. Thank you very much. I think I promised this would be about 10 minutes, and
all right.
Close that, but thank you very much. I really appreciate it.
Okay, thank you.
Talk with you soon.
All right, bye.